Um, Welcome back. So this is still Declaration D136, Segment 3, Part 2. This is a continuation of the previous segment in which I was describing, the escalation with the CAPIAS order and how I responded to that. And I have to tell you, I got information from this person in the Venezuelan intelligence that it's passing me information. I know the state of things on the other side. But I'm gonna talk about that later. Um, so for this segment, what I would like to do is to basically give you a timeline of the important events in this case. Um, I want to record them here in case authorities come across this video. It would be a quick way for them to know where to look. Instead of conducting I imagine they will probably conduct a full audit on the entire docket, right, and the logs of the Odyssey system and all that. But um, it's a shortcut, right? If I can tell you, what are the things that they did, probably it will be easier, faster. But before that, I have to tell you, I usually when for people that are, I guess, new to this situation. Um, this may sound, what I'm going to tell you is, what I'm going to say is probably going to sound a little bit, out there. But I need to say it because it's important, right? But if authorities see this, I imagine they will understand what I'm saying. So usually when I go buy food, I don't look up where I'm going to go or things like that. That could give them an advantage because if they have more time, they can plan better, right? To do something in the store. And I've described this before. In fact, I have patent applications that describe countermeasures against the inventory manipulation that they do, to harm people, right, at a scale. But anyhow, so today I'm going to break that rule. I'm going to tell you exactly where I'm going to go. I'm going to go to either HEB or Target. I don't know. And the reason I'm going to go to those is because I already sent legal notices to the general counsel of those two companies, putting them on notice of the manipulation of the inventory that is happening in Katy to harm me. And in one instance, at least in the instance of Target, the general counsel replied to me. So he acknowledged that he's on notice. Right? So if they do manipulate the inventory and harm me that way, I mean, I imagine there would be corporate liability. Right? So imagine the liability is higher, and therefore maybe this deters them, right? But I need to go buy food because I haven't eaten in a few days. So let me share my screen with you. Let me start with that. It would be, I think, this one. Yes. Yeah. So let me show you that because I think that's interesting, right? So if because I don't recall the name of the person. Yeah, I think it's this one. So this was, yeah. So the person that replied is Philip W. Goddard, and he works at btlaw.com. BTLaw is Barners and Sundberg, and he is I think it's the outside counsel, I'm not sure, of Target. Right? So I sent the notice to Target, and he replied. The notice is one of the potential infringement of, it's a legal notice for potential infringement of intellectual property related to the patent portfolio of 50 something patents that I described in the previous segment. And in one of those applications or two, their technologies to counter the manipulation of the inventory that they do in the stores, in the network, right? That these judiciary officers are running. They do this manipulation on the stores to harm people, right? So I send them the notice in the context of the intellectual property. But of course, if you read the patent applications, and they have to read it because it's a legal notice, and I'm attaching the patent application to the notice. So if you read the patent applications, it's clear that, I mean, it's implicit, right? That this network is doing this to harm people with food, right? And they are a food retailing company. So if they still today go ahead and manipulate the inventory to harm me, Target is already on notice, and HEB as well. In the case of HEB, it's interesting because I photographed in one of those instances 3 different Venezuelan, well, 2 Indians and 1 Venezuelan agents, followed me in the store photographing what I had in the basket. Right? So let's see. Let's see what I do with that. But again, at least I want to memorialize here that Mr. Philippe W. Goddard is on notice of this, right? Legal notice, legally speaking. And I have the receipts that he read the email, he replied to the email, all that, all the checkboxes. So now for this segment, what I would like to do is to basically walk you very quickly through the timeline of important events in this, or developments in this case, right? So at the beginning, as you saw, that we discussed in the previous segment, it was all about kidnapping the child, right? Using a combination of non-service of the hearing, then having the hearing in secret, then created a TRO, a temporary restraining order, but that in reality had 2 different versions, index number 7 and index number 8. So they can switch them depending on who asks for a copy of the order. And then not serving the order at all, right? Because otherwise it would defeat the purpose of having a dual version. And then holding this secret TRO as a enforceable order that they can use to keep the child kidnapped, and also to find me in contempt whenever they want for not complying with the conditions in those orders, or with the things that are stipulated in that order, which is what Detroit Pickett is doing in May 2026. Right? So that was the first event, right? Right after that, right, a few weeks after, the next event was the mediation, right? So here, in that the first part, right, where they create this TRO, they send me a notice for a hearing on May 15, 2025. When I go to that hearing, and remember, they are alleging that I'm delusional, right? That I have serious mental problems. That's supposedly the basis for this secret TRO that they have, right? Which is void for all the reasons that we discussed before. But that's in their heads. That's going to justify. That's the justification for that secret document, right? For that secret order. So I go to the hearing on May 15, 2025, and Judge Richard Bell orders me. He used the word order me to go to mediation. Now, this is a serious violation, because if the mental capacity of a person is being challenged by the opposing party, how can a judge send that person to mediation with that party, acting pro se, alone, without representation? It's crazy, right? I mean, that is the definition of being crazy, what that judge did. Because if a person is crazy, they cannot represent themselves. How can they participate in a negotiation that is going to affect family relationships and property? It's just a crazy proposition. But he did that, and he used the word order, and he put it in the docket. If you look at I think 515 should be here. Oh, sorry, 515, 2025, last year, right? Yes. So you see 515, it says judge docket entry. And see, the name of the hearing says temporary restraining order here, right? And so it says that attorney Hibner from the Adams law firm appeared with petitioner, responded, appeared pro se. So me, I was pro se, meaning I didn't have an attorney. Parties ordered to mediate. Right? I mean, that sentence is the proof that this is a crazy order, right? But importantly, if you read the next entries, index 15, 16, 17, you will see that there's no actual order. Like he ordered this verbally, but there's no order entered. And this is another violation. If a judge is going to order something, he has to produce an order that is in the docket. So there is memorialized what was ordered. But of course, he can't do that because he would contradict. I mean, he would not contradict, but he would clash with the TRO. Because if they have this secret TRO, and if they ever have to use it, it will become obvious that my mental capacity was being challenged. And if my mental capacity is being challenged, how can the judge order me to mediation? That's the reason why they didn't really create the order. He did this verbally, but remember, an order from a judge, even if verbal, is enforceable. I mean, I have to go to mediation. So I went to mediation. So that was the first incident. And then also important, because I'm pro se, not only they had to enter the order in the docket, which they didn't, but they also had to serve it to me by mail, by physical mail, because I'm acting pro se. And this is in the rules of procedure. And this is also not in here. So this is another violation of the process. So just in this day, 3 serious violations of the process occurred by the hands of the judge, Richard Bell. So that is the next significant event, I would say. Let me go back to my list of things. Yes. So the next significant event is July 2020. In July 2025, based on that, this judge ordered me to go. Well, before I get into that, when I go to the mediation, he ordered the mediation to take place with a former judge. I mean, the mediator is a former judge of the same court where Richard Bell works. I mean, in Fort Bend County, right? His name is David Perwin. I go to the mediation with Perwin, right? And the other party, right? Anyways, I mean, I have a transcript of it. I have a recording of it. It's hilarious, like really. So he starts, like trying to. He said that they have a proposal, right? That's how he starts the mediation. I said, listen, let's wait a second. I understand they have a proposal, but I have to be honest with you. They are challenging my mental capacity, and the mediation means that they're going to ask me with this proposal that they have to sign a contract. And as you know, because you're a former judge, a contract, for it to be valid, the parties entering into the contract have to be in full use of their mental capacity. If one of the people signing the contract is crazy, the contract is void. This is a basic legal concept. I tell this to this mediator who is a former judge, former colleague of Richard Bell. When I say that, he tells me, well, but like he tries to convince me. Like he tells me that, well, but you can be crazy for certain things, but you could be sane enough to sign a contract. Like being crazy for having a family doesn't mean being crazy for conducting a business, which is not true. Like if you're crazy, right? I mean, in a legal sense, you're either capable or not capable of, representing yourself. But anyhow, I'm not gonna start into an argument with him, right? So I tell him, listen, all I need here is, I mean, I'm gonna proceed. I'm ready to settle. That's what I told him, right? Because I wanted to get my son back. But before we proceed with even starting negotiating, I have to tell you that I have only one request. My request is that the other party writes a handwritten note. It could be in an app. I don't care. It doesn't have to be a formal document. Even an app will do. But a simple note handwritten by her saying that she has no reason to believe that I cannot sign a contract with her today, and signed by her, right? It's a simple request for somebody who wants you to sign a contract to give them money, property, and possession of the child. She said no, right? I mean, in reality, I know it was Perwin that said no. Well, it was Perwin's boss who said no. But details aside, they said no. The reason they said no is because, remember, they are challenging my mental capacity, and that is supposedly the justification for this secret TRO that they have created in April 2025, with which they have had this child kidnapped for more than 50 days. So they can't give me anything in writing that says that I'm not crazy, like that handwritten note. That's why they refuse. Right? So this is the second significant event. The third significant event is that in July 2025, there was another hearing, right, after the mediation impasse. I think uh, was this, right, in 723. So when the mediation fell apart because I asked for this simple note and they refused to give it to me, um, then Morgan Habner immediately filed for a motion for psychiatric evaluation, which is a Russian tactic to discredit whistleblowers. Like this is the Russians have been doing this for almost a century at this point. But that's what she did, right? Immediately. She filed for a motion for psychiatric evaluation. Importantly, 3 days after this motion was filed, in a recorded conversation, the other party admitted in a recorded conversation in video, and I have the transcript and everything, that if I had agreed to the mediation, there would be no need for this new request for a psychiatric evaluation. So basically, the other party was admitting that this motion for psychiatric evaluation is a bad faith litigation tactic. It's not out of legit concern for the child. This is another significant event. Now, after all this happened, I immediately filed the first verified motion to recuse on the basis that Judge Bell put me in harm's way already by ordering me to go to mediation, knowing that the other party was challenging my mental capacity. Richard Bell refused to recuse himself and tell Fair as well, and they forwarded that to the Honorable Susan Brown, and she denied the motion. So I had to continue with the case, although these two judges had already put me in harm's way in this horrible way multiple times. Right? So this is the fourth significant event. Then the next is not one event, but a series of events between August and September 2025. I filed multiple motions, trying to, get all these things that they were doing squashed, right, and get my parental rights back, and asking them to. I filed a motion to compel production of the actual TRO. Anyhow, they ignored all my motions, which is what I was telling you before in the previous subsegment, right? That the main vector of attack is ignoring any motions that would benefit the target or the defendant, as they called it, or the respondent. Right? And they ignored all my motions. Right? Then on September 2025, I reported Judge Telfair and the attorneys that were doing this at the time. It was the Adams law firm, so William Kyle Adams and Morgan Hyper. G. Troy Pickett hadn't come out from behind the curtain yet, but I reported the three of them to the IRS, and Josh Brown as well, because of the data that I have. I mean, I didn't do this out of revenge. I did do this based on data that I'm seeing on the geo index that was given to me by the Venezuelan intelligence the year prior, on 2024. But I hadn't taken that step because until that point, I was thinking that even if they're marking the index, and I know they're working for the network, not only because they're marking the index, but also the timing of the lawsuit and many other things, right? I thought, there would be a line, like, there would be an ethical line that they wouldn't cross. But when I see that they are doing all these things, it's clear to me that there's no line. So I took the step of reporting them to the IRS. And importantly, um, in one of my books, the cover, I described this in one of the demos, the cover is generated algorithmically with pictures of people that are part of the network, right? And the sizes and the positioning of the pictures encode meaning. Morgan Heimler, Telfair, and Susan Brown are in this cover, right? And this book was published on July 2028, before I reported them to the IRS. Like, so it was an escalation, really. I started by putting them in the book, and they kept doing this, so I reported to the IRS. Right? But anyhow, the next significant event is that on September 9, 2025, there is a hearing for temporary order, right? Which is the order that now they're using to keep the child kidnapped until now, right? This would be September 9, 2025. So it's this one, September 8th, actually. September 8th. Temporary orders hearing, right? So it's after index 44, like the next three entries. So in that hearing, and this is a significant event, Morgan Heibner introduces into evidence my book as a way to call me crazy, like to say that I'm crazy, and to also supposedly provoke the judge, right? So if there is an adverse judgment, it could be explained, I mean, an adverse and arbitrary judgment, right? It could be explained as well, is that he upset the judge because he put the judge in the book because he's crazy, right? Something like that. But importantly, she introduces the book into evidence. And not only that, while she has me on the stand, she asks me if that is my book, to which I respond, yes. And then she hands the book to the judge, and the judge examines the book while I'm on the stand, right? He doesn't, directly addresses the issue, but there is evidence that he saw the book with his own eyes. This is important because he's in the cover of the book. Now, this immediately should have triggered the judge to recuse himself, because he should know that he cannot be impartial, or that even if he could be impartial, his objectivity could be reasonably questioned by anybody. Because how could anybody could think, well, if this person wrote a book about judiciary corruption and put you, the judge, in the book, how could you be partial? Right? He should have recused himself in that moment on September 8th, 2025. But he didn't. He kept going. Right? He kept harassing me with the powers that he has in the court. So this is another significant event. I mean, the fact that the judge has the book in his hands while I'm on the stand, and Morgan Heibner is the person that introduced the book in the evidence, right, of the case. Now, this is all important because this is one of the main points I make in the third verified motion to recuse, which is today in front of the Supreme Court of Texas, and that is pending for ruling, and that they have ruled on it for 4 months. And that at the end enabled all this to escalate to a capias order that has had me under de facto house arrest for a week without the possibility of eating. Right? So all that stems from that event of the judge having the book in his hand while I'm on the stand, and the book wasn't introduced by me. It was introduced by Morgan Hagner. And the book was written months before that hearing. It's not like I wrote the book to create the situation. No, I wrote that book, and I didn't even tell the judge that I wrote the book. Right? It's Morgan Heibner who told the judge. So that judge should have recused himself that day on September 8th, 2025, but he didn't. And that is significant, right? Let me see, what is the next one? Yes. Yes. So anyhow, after I see this escalation on September, right, with the judge, and then when they signed it, when they Morgan Heibner started drafting the temporary orders, right. So it was a process in which Morgan Heibner submitted a draft of the temporary orders that had nothing to do with what was discussed in that hearing. She included things in there like I would have to give her the passport of the child, and I have to pay rent for the petitioner, like all sorts of things, like to harass me. And I kept objecting to all of them. But anyhow, once I see, like, and they kept delaying this process, like they would never sign the orders. So at some point, based on all this mountain of evidence, and the fact that the judge already knows that I wrote a book and put him on the cover, I filed a second verified motion to recuse. And the same thing happened, right? It went to Susan Brown, and Susan Brown eventually, months after, denied it. Right? And this enabled the harassment to continue. But the significant event here is October 15, 2025, because I filed in the next day, there was a hearing in which they were going to impose more temporary orders. I can't recall exactly what it was, right? But it was something heavy. This was to take place on October 16th. Uh, let's see if I'm correct, remembering this correctly. Hmm. I think that it's not in the docket anymore, but there was a hearing yeah, they've removed it. There was an entry for a hearing. I have snapshots of this docket, like, hourly for the last year. I can find it, but there was a hearing, right? So the night before the hearing, I filed the second verified motion to recuse based on this mountain of evidence that this court is obviously first biased and secondly being actively used as a weapon. I filed the motion to recuse after the court was closed. It was like 7 p.m. And what they did, the judge signed the temporary orders at 11 p.m., something like that, like 4 hours after I filed the motion to recuse, which is, it's a violation because, again, once that motion to recuse is filed, there's no discussion. The court is under an automatic and mandatory stay. The judge had no authority to sign that order, but they did it out of desperation. And importantly, what they signed was a version of the order, supposedly, right? What they signed was supposedly a version of the order that that I had contested, like, and that there was obviously no agreement, right, on that. Um, but that's what they did. But again, that order is void because it was signed without jurisdiction. The court did not have jurisdiction. But importantly as well, if you see, it says, the court signs the temporary orders, right? So this is the same multi-step process that I was describing before, right? And you see on index 89, supposedly they are the temporary orders, right? Which if you click on it, well, maybe because they're rolling back, maybe now it's downloadable. But all this year, if you click on that link, you cannot download the order. Let's see. Let's see if it's downloadable. Okay, now they made it downloadable, right? Okay. So here you go, right? So now you can download it. But for the entire year, it wasn't the case. But now, right, the important thing here is not that. It's not whether it's downloadable or not. It's the following. If you see, and we talked about this just a few minutes ago, in the entry where they're supposed to post proof that they sent me the notice, right? It says unable to forward, right? So they're saying in this entry, index 91, that I didn't receive a copy of this order. And this makes the order void, because how can an order be valid and enforceable? I mean, despite the fact that it was signed out of jurisdiction, right, without jurisdiction. But on top of that, I never received a copy of the order, and it said it right in the docket. Now, and this is interesting, and this is very interesting of how sloppy they are when they do these things, right? And that's why they get caught by my system all the time. If you look at this, right, supposedly the order was 89, right, on 10/15, right, is when the order was entered, right, was entered into the docket, right. Uh, yeah, this is a complete fabrication. You can see this, right. Well, first of all, right, index 88, what is in there? Index 88 is misplaced over here, right? It's down here. I mean, it doesn't. The temporal sequence is broken. Like the sequentiality of this is broken. Also, and I know this for a fact, if you look at my motion to recuse, which is index 80, exactly. If you look at my motion to recuse, which got index 88, they put the date as if it was filed on the next day. This is to justify that the court did have jurisdiction. This is what they're doing this, right? But you can see that this is not true because I got the lower index. I mean, my motion to recuse has index 88, but the supposed order has index 89. So it has to happen after. So if my motion to recuse was filed on the 16th, it means that the order was really signed on the 16th of or after. How can it be signed before and get a higher index? This is impossible, right? By pure logic. So you can see here, this is manipulated, right? But the other thing that is incredible here to see is that supposedly on index 91, on the next day, so supposedly on the next day after signing the order, they already know that the mail on USPS was unable to be forwarded. How is this possible? I mean, how can they, in less than 24 hours, send the order by mail and the order travel through the USPS system, get to the valid side property, and be returned to the court and arrive to the court so the clerk can see that it was returned in a space of 24 hours? This is impossible. This process in reality takes like 10 days because the mail in USPS, this standard mail class, takes like 5 days to arrive. So it will be 5 days to arrive to me, 5 days. Well, say that it's because it's in Katy and they're super efficient in the routing system. Say that it takes 3 days. It would be 3 business days to arrive to me or to attempt to arrive to me, and then unable to forward, and 3 days to go back to the court. So it has to be at least 6 days apart. How can this unable to forward notice be on the next day after the order was supposedly signed? You can see here that they manipulated it, right? But they do it in a sloppy manner. So this is the next significant event. But to drive the point home, this order is void first because it was signed out of jurisdiction, and you can see that in the sequentiality of the indices. That is after the motion to recuse was filed. Also is void because I never received the copy of the order, and this is clear in the docket. And this is the order that they're using to serve all to remove, to strip all my parental rights, right? And keep the child basically kidnapped, right? Using this precise order in combination with the secret TRO. So they're basically using the conditions that are embedded into the 2 orders, right? To keep the child kidnapped and find me in contempt of things that I didn't even know, that I still don't even know that are in one of those orders. So that is the next significant event. So because they never sent me with the order, I started filing motions asking to compel compel production of the order, right? And in one of those instances, in November 7th, 2025, Troy Pickett responds because the situation was inescapable. I was filing these things in federal court. So he responds, yes, the order was signed, because at this point I didn't even know that the order was signed, right? He responds, the order was signed and it was entered, and here's a copy. Like, that was the first time I saw that order on November 7th, right? 3 weeks after, right? They did all this. There was another instance in which, this is also significant, in which I think this was on, so look for notice of entry, temporary orders, right? So this was on 9/29, October 7th. Yes, this one. So this notice of entry temporary orders is another instance of this, right? In which Morgan Heibner created a deceptively titled document called Notice of Entry Temporary Orders, but if you read the document, it's not really a temporary order. It's really a notice of hearing for a temporary order. The same thing they did in 2025 when they sent me a notice of hearing, but titled as if it was a temporary restraining order. So this is a standardized procedure, right? You see. They entered this, and this is to create a record in the docket as if the order was really signed. But at this point, the order is not signed, and this is admitted by Troy Pickett on November 7th, when he files a document saying the order was signed on October 15th. That's what he's saying in the November 7th file. So Troy Pickett is contradicting Index 77 in writing in a document. I mean, both cannot be right, right? Either Morgan Heibner lied here, and Morgan Heibner works for the Adams law firm, which is controlled by a relative of Terry Adams. So either the Adams law firm lied on Index 77 or Troy Pickett lied on November 7th. But the two things cannot be true at the same time because they're contradicting themselves. So this is also significant. So the harassment continued through this contradiction of after the contradiction of November 7th by Troy Pickett. The legal harassment continued through November, December, and January. Right. On January 7th, I reported the judge and the attorneys that are doing this to the DOJ, and I started a process of creating uh, formal criminal complaints and supplements and sending them to the DOJ. And maybe they block them, but I have copies, right? So they all exist and they document all the events of harassment that they did through the last 3 months in this period, right? Then the next thing that happened on January 14th, I filed the third verified motion to recuse the judge based on all these things, but importantly on the fact that he saw the book on September 8th, 2025, with a depiction of him in the cover. And he, at that point, acquired a mandatory duty to recuse himself that he cannot escape. And he didn't. And not only he didn't, but then he continued to harass me, abusing the power of his office, and to deprive me of my constitutional rights and civil rights under the color of state law, which is a federal crime. So it's what can I say, right? And then the rest of the events, yes. So the rest of the events are described, right, in the previous segment, right? So after January 14th, what happened was basically on January 27th is the next significant event in which Judge Susan Brown, because in that motion, I also asked, in fact, let me show you this, right? So if you go, because this is in the Supreme Court of Texas at this point, right? So if you search for Supreme Court of Texas, let's do the exercise of looking again that case, right? So we're gonna do a case search, and we're gonna do 26-0511, and we're gonna read that petition for writ of habeas corpus, because there I attached the still verified motion to recuse, I think in the appendix 1. Yes. So in that motion to recuse, I attach a copy of the book, of the cover of the book, not the book, but the cover, right? That shows Telfair and the Honorable Susan Brown in the cover. And this is in the Supreme Court of Texas, right? So Susan Brown had also the duty to recuse herself. And I made this clear in this motion to recuse, right? So I asked that she doesn't make a decision on this motion because she's also in the cover of the book. And she's also in the Form 211 that I sent to the IRS. And you can see that here. I attached to the motion to recuse the IRS form that I sent to the IRS reporting them, which is my right to do. I have the right to report them. Like, it's up to the IRS to decide if my claims have merit or not. But they cannot retaliate against me for making that report. It's a right that I have. And if you see here, you can see I obscure all the other names, like to not make this a controversial topic. But you can see that on the line item GA 11 is the Honorable Susan Brown, and on GA 12 is Judge Oscar Telfair. This is the form that I sent to the IRS as a whistleblower. Right here, you have the certificate, the mail, certified mail, me sending this to the IRS, with the barcode, right? I mean, here you have the signature from the IRS office receiving the package. Uh, Also, here's the form in which I reported Troy Pickett, the attorney that is harassing me with all this, right, in this specific court. And again, here you have the envelope that I use and everything, right? And here you have the copy of the book and annotated uh, with the positions in which Oscar Telfair is. You can see him, like it's very. I don't know if it's visible, if it's going to be visible there. Increase it, right? But you can see that Oscar Telfair is here in this part over here, right? Um, like if you follow the name with the line, and the Honorable Susan Brown is also here, right? So she had the duty to recuse herself as well. But she didn't, and she forwarded this to the Supreme Court of Texas, right? And the Supreme Court of Texas has this since January 27th. After January 27, the legal escalation not only continued, but increased. This is when Troy Pickett started asking for sanctions, additional temporary orders. And remember, the court is under an automatic and mandatory stay because this motion is pending for ruling. And Judge Telfair and the scheduler of the court, which is one of the main, more dangerous weapons that there could exist, the scheduler of the court kept scheduling more hearings because when the scheduler schedules more hearing, although the court is under mandatory stay, this opens the opportunity for Troy Pickett and the judge to escalate, right? So the combination of the court scheduler, the judge, Telfair, and Troy Pickett, the three of them continued creating these hearings and not notifying me of the hearings, then entering void orders, and then finding me in contempt for not following those orders. And all this process at the end terminated in the creation of that capias order that was proposed on May 14, 2026, and signed, as the docket says, and you can see that in the docket, uh, here on 5/15, that the court signed the capias, right? So all this process culminated into this capias order that is by all means and in all practical senses, limiting my freedom. I'm basically under a de facto house arrest unless my brother is here to take me to the store to buy food. And he had to come here from Canada. I had to ask him to come. Imagine what that means. I had to ask my brother. He had to leave his wife, his child, everything, to come here to take me to the store to buy food. Because this judge, Troy Pickett, and the court scheduler did this. So I don't know. Let that sink in for a moment, what that means to the freedoms, not of me, but to the freedoms of all of you who are watching this. If they can do this to me, they can do this to you as well. So think about that for a second. So with that, I wanna make a pause on this one. I have a few other topics more on the technical side, and I'm gonna record that in a segment to follow after I go to either HEB or Target to buy food after a week of deprivation of food by the hands of the court scheduler of the 387th, Josh Telfair, and G. Troy Pickett. And it's important to note that Target and their general counsel or outside counsel, I don't know, and HEB and their general counsel or outside counsel are on notice that they are manipulating the food supply chain in Katy to do this, right, to harm me. So be careful. Well, with that, I'm going to say bye for now. I thank you for your time, and I'll see you in the next one.